The task force on antitrust will come to order. I'm happy to see so many of our friends here. I note that Jack and Jill Incorporated's national board is here for the annual legislative event, and so is its president, Jacqueline Moore Bowles. We welcome all of you. Would you just stand up for 1 minute? 1 second. Thank you. Very good to see you all. Ladies and gentlemen, over the last 10 years, the Internet has gone from its infancy through a period of exponential growth. Today, over 1 and 1/3 billion people use the Internet, which is approximately 20% of the world's population. In the last 7 years alone, worldwide use of the Internet has jumped 265%. The Internet has become the dominant venue for the expression of ideas and public discourse. From social networking to get-out-the-vote drives, the Internet is now a leading tool for speech and action. Websites like Facebook, MySpace, LinkedIn, and Monster have changed the way people of all ages connect socially and professionally. Political candidates raise more money online with each election cycle. Newspaper websites and independent blogs have revolutionized the ways in which news and media are disseminated and consumed. And the Internet has opened up new performance venues to emerging artists and entertainers. In these and other ways, the technological innovation and communication made possible by Internet has made it among the most powerful outlets for creativity and for free speech. So when it comes to the Internet, we should proceed cautiously. Unless we've clearly documented the existence of a significant problem that needs regulating, I do not believe Congress should regulate, and even in those instances, we should tread lightly. Today, the open architecture of the Internet is under siege. On today's Internet, a blogger can compete on a level playing field with news giants like CNN or the New York Times. An independent musician can stand equal with a record label, and citizen advocates can have as loud a voice as politicians themselves. However, some of the Internet service providers, which control 96% of the residential market for high-speed Internet access, are either monopolies or duopolies in most of the areas of the country. There are either one company or two companies controlling it, and have proposed now to give favored treatment to some Internet content and disfavored treatment to others. Under these proposed business models, what treatment you get will be determined by how much you pay, or potentially whether the Internet service provider approves of the content that you're sending. If you're sending it over their pipes, or perhaps the Internet service provider may have a financial interest. The problem is that many of the innovations we've enjoyed on the Internet would never have occurred under this proposed regime. We would never have had a Google search engine, or YouTube videos, or daily cost blogs if pay to play had been our national policy. To be sure, if we go in this direction, it will stifle future innovation on the Internet. And so I'm concerned that if Congress stands by and does nothing, we will soon find ourselves living in a world where those who pay can play, but those who don't are simply out of luck. Where politicians will be able to stifle the voices of citizen activists through deals with Internet service providers. Where an increasingly consolidated entertainment industry might be able to prevent independent artists and filmmakers from being heard. Now, if Congress acts, it will not be because we have decided to regulate. It will be because the Internet service providers have imposed their own new regulation on the Internet and are interfering with its healthy growth. I believe that antitrust law is the most appropriate way to deal with this problem, and antitrust law is not regulation. It exists to correct distortions of the free market, where monopolies or cartels have cornered the market and competition is not being allowed to work. The antitrust laws can help maintain a free and open market. So help maintain a free and open internet. And so this is a very interesting subject, and I'd recognize our ranking minority member, Steve Shabbat of Ohio, for his opening comments.
Thank you, Mr. Chairman. I'd like to thank Chairman Conyers for holding this hearing today. I'd also like to thank our witnesses for taking the time to discuss this important issue. Net neutrality is not a new issue to this committee or to Congress, and debate in the past has been, quite frankly, very passionate. I think we can all agree, though, that the Internet has changed the way that we communicate, learn, and do business. It has changed the way we access and use information. It has changed the way we access and use technology. The Internet has flourished in a relatively regulation-free environment. For example, the Internet tax moratorium, first enacted back in 1998, that was recently extended for an additional 7 years, will continue to allow greater public access, benefiting everyone, from consumers to teachers and students, to the corporate sector and rural and urban areas alike. And it is the free market that will continue to allow the best possible service at the best possible price. Too often, Congress sees the problems that it believes it can fix. But legislation is not always the right answer. Competition is. Competition drives the market to become as efficient and effective as possible, providing consumers with the right quantity at the right price. It has worked in the past, and I believe that it will continue to work in the future, particularly as it relates to the Internet. Unbeknownst to many of us, there is an entire network structure that manages data traffic, enabling anyone to access virtually anything at any time. It's necessary to ensure that the most effective network infrastructure is in place to connect consumers to content. I am concerned that the heavy hand of government could deter investment in innovation and technology that will enable networks to advance in the future. Burdensome regulations, particularly in this case, may actually slow the development of bandwidth, reducing the efficiency and effectiveness of the Internet, ultimately harming consumers. I look forward to addressing these concerns with our panel of experts today. And again, I want to thank the Chairman for holding this important hearing, and I yield back the balance of my time.
Thank you. You're welcome. Would Chairman Smith, the ranking member of the full committee, do you have a comment?
Thank you, Mr. Chairman. Like you, I welcome our witnesses here today. I do have an opening statement, but I'd like to ask unanimous consent that it simply be made a part of the record.
Without objection.
And I'll yield back, Mr. Chairman. Thank you.
Jim Sensenbrenner, Chairman Emeritus, have you a comment?
A little bit, Mr. Chairman. Thank you very much. In the last Congress, when I was chairman of the committee, I joined with then-ranking member Conyers to introduce legislation. And the purpose was based on two principles. One is that the antitrust law should apply to the telecommunications industry. That remains my position. And the second was that I believe that it was important that this committee exercise its jurisdiction in this area, because antitrust laws are not regulations in that some federal agency tells you what you can do and what you can't do, but if somebody is aggrieved, they can file a lawsuit, and if they are able to prove anti-competitive action, then they can win triple damages. I would hope that as the debate on net neutrality and what to do about telecom and internet regulation or lack thereof goes on in this Congress, the current chairman and ranking member at all costs move together to make sure that the Judiciary Committee maintains its jurisdiction on this subject. Because if we allow our jurisdiction to go to the Energy and Commerce Committee, I think you will see a regulatory structure over the Internet that is not going to be good for the American public, and it's not going to be good for artists and others that use the Internet as an essential means of communication, such as the witnesses that we have here today. Thank you.
Thank you, sir. Rick Keller, have you a comment?
No, I don't, Mr. Chairman, but thanks for asking. I just appreciate all the witnesses being here.
Mr. Feeney, welcome.
Thank you, Mr. Chairman. This is my first hearing, and I'm very anxious to hear the various issues explored. I'm somewhat familiar with the Internet and intellectual property and even antitrust. I've heard of horizontal monopolies. I've heard of vertical monopolies. I guess when we're talking about wireless, it's sort of a ubiquitous monopoly, and that's a new thing for me to understand. With that, I'll yield back and listen very carefully.
Thank you. Our witnesses are Susan Crawford, professor, Professor Christopher Yu, our old friend, director of ACLU, Washington office, Carolyn Fredrickson, Rick Carnes, president of the Songwriters Guild of America, Michele Combs, vice president of the Communications Christian Coalition of America, and of course our lead vocalist and guitarist, OK Go, Damian Kulash, a vocalist and musician, a native of our capital, a graduate from Brown University, who formed his organization in 1999 with 3 others. His band released 2 albums and won a Grammy Award for one of its musical videos in 2007. They attribute their breakthrough in part to the popularity of its videos, which the group has uploaded and disseminated. Looks like he's trying to play them here. Disseminated across the world on video websites like youtube.com. Welcome, Mr. Kulash. We'd love to hear, see, and listen to your remarks.
Thank you, Mr. Chairman. Mr. Chairman, Mr. Ranking Member and members of the committee, it's a real honor to be here. I'm a rock singer, so I have some experience getting up in front of a microphone, but put it this way, you're not my usual crowd. I'm here today because my band, OK Go, is among the first to have truly found success on the internet. I don't know if I need to tell all of you guys my story or not. I'm getting the sense that maybe you guys are Cool Rep 2000 and Chairman Rock that we already see on our message boards every day. But just in case, I'm going to tell you a little bit about our story and the videos that we put on the internet, and I want to show you a couple of those videos today. Our band started out the way that every band did 10 years ago. The traditional music industry was very much still in full swing, and it served a real purpose, which was to connect musicians who wanted to get their music out there into the world with the people who wanted to hear it, and there are people all over the world who wanted to hear that music. So a big industry grew to connect those dots. We worked in that system. We started out playing shows in Chicago at local clubs where we started. We plastered our posters up all over town. We took as much time off from our day jobs as we could to go touring. And eventually we developed a big enough fan base that we could, that we landed that rare prize, the major label record deal. Our first record, which we put out in 2002, did moderately well. We got to about 100 on the Billboard charts and just barely broke into the top 20 of the modern rock radio charts, which is something of a feat. And to translate these numbers, we basically were in the middle of the pack. We were doing much better than most musicians. Felt very, very lucky to be doing what we love for a living, but we're still definitely struggling for every fan we could find and frankly, struggling to pay our bills as well. So we put out a second record, and this time we thought maybe we would add our own promotional ideas into the mix a little bit. We still did everything that our record label asked us to do, and everything that every band would do. We, the free shows for radio stations, the nonstop touring. We'd go to the Fox Morning News studios and play an acoustic song for the people of Houston. But we also decided we'd start our own online campaign. So if you don't mind, I'll show you the first video here that we put online. Uh-oh. Well, I thought I'd play it. There we go. I don't know if you can hear this song here, but that's us dancing in my backyard. My sister helped us choreograph this pretty ludicrous routine as basically as something. Let me turn this down. This was something we were going to do on stage. It was just planned as sort of a way to surprise our fans. There's really nothing more exciting than seeing a rock band in the middle of a show just drop their instruments and break into dance. All we really wanted was to see 500 or 1,000 jaws on the floor at the end of the show. So we came up with this routine, and we were practicing it in my backyard. We shot this videotape, and the clip itself is just, there's something really compelling about it. And when we saw it, we realized we got to put this out for our fans. So we put it on the internet, thinking just our most hardcore fans, the dedicated few, would see it. And within a month, it had been streamed and downloaded, viewed several 100,000 times. So we realized that more people had actually clicked through to this video than had purchased our first record after 18 months of touring. Then what was really pretty crazy is, let me go to the next video here. The next thing that started happening was our fans started posting their own versions of the video. Our fans would go and learn the choreography and then tape it themselves and post it on the internet. What I'm about to show you is, it's pretty crazy. This is a fan of ours found hundreds of these homemade videos online and compiled several of them together in sort of a composite video. So here are some of them. We got these videos from all over the world. We've gotten them now from 5 or 6 continents. We've seen them performed at people's weddings, in the middle of Walmart. That right there, that's my backyard. They blue screen themselves into my backyard. We saw them in churches. We saw them in local firehouses. Thousands of people were involved in sending us these videos, and it really is something that never could have happened 5 years ago. I mean, this is a connection to our fans that simply was unthinkable before. You're usually held at an arm's length from your fans, but here we were connected directly to them and them to us, and that's a really amazing feeling for someone making music. But not to be outdone by our fans, of course, we decided we needed to post another video, and so we went to my sister's house and we made this one. Once again, of course, this is just a home video that we made, and it's just one long shot again. As you can see, we're dancing again, but this time on 8 moving treadmills. For the record, I'd like to say that we assume no medical liability for any of our fans who might try to duplicate this one. This video, we figured, we'd put it online, and it would probably do about what the first one had. We thought we'd basically done as well as anyone can do online with a video. We'd already broken all sorts of records. And in the first 2 days we put this online, we posted it to YouTube, we had 1 million views. As you may have seen on the full screen view there, this video now has been, this single posting of this video has now been viewed 31 million times. Let me stop this, sorry. So, this video, of course, 31 million views. I mean, this has taken us all over the world, and it's been incredible for our band. We can now play in countries to thousands of people where our records are not even commercially released. And what's sort of most impressive is that we're actually making real money for our standard model record label as well. We now license music all over the place. We sell real records, and it's clear that our creativity has actually been a success for everyone. No matter how you slice it, we're a successful band now. So if people are wondering if the music industry will benefit from net neutrality, I don't think they need to look any farther than us. I mean, we're musicians and we are part of the music industry. I don't think there's really anyone out there who wants to see this business flourish more than we do. I'm here today representing the Future of Music, excuse me, the Future of Music Coalition's Rock the Net campaign. There are 800 other bands who have signed up with us in the last year and 125 labels who are on board. There really is some consensus here that net neutrality is good for music and good for musicians. It's allowed us to innovate and to create in ways that just were never possible before. Keep in mind, all of us are businessmen too. We want to get paid. I mean, everybody wants their hard work to be recognized. And what we really need is a legitimate digital marketplace for music. The only way that's going to happen is if we build on a level playing field. So members of the committee, Mr. Chairman, I'm here to ask you today to preserve net neutrality and the openness of the internet. I believe it's critical to the future of music.
Mr. Kulash, I don't know how to break this to you, but there are a number of people up here that think that we could do that too. And maybe better than some of the ones that you've seen.
I don't doubt it, sir.
Would you be willing to accept a Judiciary Committee video showing our steps?
It'll have to be submitted by the same means as everyone else, sir, but yes.
Well, I was for net neutrality when we started this hearing. Michele Combs, Christian Coalition of America, we welcome you. You started in South Carolina as Executive Director of America 2000, the Educational Service Corporation. Special events company you started in 1992, managed functions for both the Republican National Convention and the Democratic National Convention, hopefully not at the same time. You did something for the late Senator Strom Thurmond. We'll find out what that is. Oh, and President George Bush's inauguration.
Yes.
Which one?
2001.
All right. We welcome you. We have your written statement. All statements will be introduced into the record. We're anxious to learn more about your position on this subject. Welcome.
Thank you. Thank you, Chairman Conyers. And distinguished members of the Committee of Judiciary, my name is Michele Combs, and like Chairman Conyers said, I'm the Vice President of Communications for the Christian Coalition of America. And thank you for inviting me to testify on this very important issue of net neutrality. The Christian Coalition of America is the largest and the most active grassroots political organization in the country. We offer people of faith a vehicle to be involved in shaping their government. Christian Coalition is a conservative political organization which is made up of pro-family Americans who care deeply about becoming active citizens for the purpose of guaranteeing that government acts in ways that strengthen rather than threaten families. Use of the internet has allowed the Christian Coalition to engage Americans in a way that has revolutionized their ability to be heard and to engage in the political process. The Christian Coalition website is visited by millions of Americans every year. In addition, we send out email alerts every week to hundreds of thousands of supporters and have available our voter guides, as many of you know, every election cycle. Our state chapters also have their own websites, and many of our supporters would not be able to keep up with legislation in the legislative process if they were not able to access these websites on a daily basis. The reason the Christian Coalition is for net neutrality is simple, because we believe in freedom of speech on the internet. Organizations such as ours should be able to continue the use of the internet to communicate with our members and with a worldwide audience without a phone or a cable company snooping into our communications and deciding whether to allow a particular communication to proceed, slow it down, or offer to speed it up only if the author pays extra to be on the fast lane. Free speech should not stop when you turn on your computer or pick up your cell phone. The Christian Coalition testified some time ago on this issue, and many members of Congress promised to act if network operators block political speech. We are here to say the time has come. Recent actions by the nation's biggest phone and cable companies should be of grave concern to all those who care about public participation in our democracy. Consider these recent examples. Last fall, Verizon Wireless censored text messages sent out by NARAL. When NARAL protested, Verizon Wireless said not to worry because the company would also block the speech of pro-life advocates such as the Christian Coalition. Now let me assure you, Christian Coalition and NARAL agree on almost nothing here in Washington, D.C., but we do agree that Verizon's censorship of political speech was wrong. Verizon claims it has changed its policy. I ask you, should the company have the right to make this decision in the first place? In August 2007, AT&T censored a webcast of a concert by the rock band Pearl Jam just as the lead singer started talking about politics. Also, in October 2007, the Associated Press reported that Comcast was blocking consumers' ability to download the King James Bible using a popular file-sharing technology. It also pointed out that Comcast's discriminatory conduct just so happens to block access to video distribution applications that compete with Comcast's own programming. I asked the committee, if Comcast created a Christian family channel, would Congress allow it to block access to a competing product from the Christian Coalition? If phone companies cannot tell Americans what to say on a phone call, why should they be able to control content or tell us what to say or send a text message or an email? The Christian Coalition of America does not seek burdensome regulations, as we prefer less government to more, and we do not believe that government should censor speech. But right now, the telephone and cable companies are invested in the same kind of censorship and content discrimination technologies that are being used today by the Chinese government to block the Christian Coalition from reaching Chinese citizens. Finally, faith-based groups are turning to the internet to promote their political rights, to engage what Ronald Reagan called the hard work of freedom. We should not let the phone and cable companies interfere with that work and getting our message out to the millions of Americans who want to make this country a better place for their children and grandchildren.
Thank you very much. Songwriters Guild of America, Mr. Rick Carnes, President of Songwriters Guild of America. He's 21 million records have been produced from songs that he's written. Dean Martin, Tricia Yearwood, Garth Brooks, and Reba McEntire, and it goes on and on. Under Mr. Carnes' leadership, the Songwriters Guild has become a leading advocate on creative and artistic issues. We welcome you to the committee, sir.
Thank you, Mr. Chairman, and Ranking Member Smith, and members of the committee. Thank you for this invitation to discuss the songwriter's perspective on net neutrality proposals and antitrust laws. My name is Rick Carnes, and I'm president of the Songwriters Guild of America, and this year marks my 30th year as a professional songwriter. No issue is more important to songwriters who have seen their livelihoods and professional futures devastated by internet piracy. Today, the songwriting profession is like a person drowning in quicksand. Some of us barely have our heads above the surface, but we're up to our armpits, and there's a chance that new technologies to detect and deter illegal file sharing might save us. But I'm concerned that pending regulatory and legislative proposals could discourage the development of those technologies, and therefore cause my colleagues in my profession to drown. Chairman Conyers and Congressman Smith, over the years there have been no greater advocate for songwriters than you and your colleagues on this committee. We truly appreciate the responsiveness of this committee to the copyright and technology challenges we have faced together over the past 15 years. So as the committee considers the competition aspects of the net neutrality debate, I wanted to provide you with our perspective on how authors, writers, and composers are affected by potential regulation of the internet. As I have testified before this committee, internet piracy is damaging the music industry and killing off the songwriting profession. As a matter of fact, my own publisher had 12 songwriters on staff in 1998, and they had one on staff in 2008. The devastation is almost total now. Recent studies indicate that 70% of the volume of the traffic on broadband networks is P2P traffic, relating to 5% of the users, and easily 90% of that traffic is unlawful. That's the real bottleneck in the internet now. A 2008 UK study by the Wigan Group found that 70% of those surveyed said they would stop illegal file sharing if their ISP notified them in some way that it had detected their practice. In other words, the problem of illegal file sharing is unacceptable, and the misconduct committed by a small group of people is causing the problem, many of whom would stop if there were technology to warn them to stop or to make them stop. Some network operators, such as AT&T, are now considering technological means to identify and filter illegal content over the internet. Technology has hurt our profession, but at last, some more technology might finally save it. As a songwriter, I can tell you that my choice is to have my works distributed by someone who is invested in trying to stop the digital theft of intellectual property. Indeed, I would believe it would be to the economic advantage of broadband operators to take such steps, because the quality of content they distribute would increase, and many consumers would prefer their service. In other words, there is evidence that the marketplace might finally be working here to reduce internet piracy, so it is with great concern that I read the proposals that would prevent ISPs from managing their networks in order to relieve the congestion, when that congestion is largely caused by illegal file sharing. Some proposals in the Commerce Committee and the FCC would prevent ISPs from taking necessary management actions, and I believe those proposals are without justification. But so too should this committee proceed with very great caution on antitrust proposals that would expand the current laws that protect consumers against unfair competition on the internet. Antitrust legislation in the prior Congress, H.R. 5417, would have created a presumption that broadband operators were acting unlawfully unless they could show that their network management or anti-piracy actions were non-discriminatory or fit into certain narrow exceptions. I am confident that this legislation did not intend to discourage the developing technologies that could counteract the digital piracy epidemic, but I am concerned that that might have been the result. The last Congress's antitrust bill could have prohibited ISPs from discouraging illegal content practices and would have prohibited the ISPs from encouraging their customers to patronize sites that adopt lawful copyright practices. I strongly urge the committee to think this issue through further, because that result would be very harmful to songwriters. Here's one final thought on legislation and regulation on net neutrality. It strikes me as odd that the problem of broadband network congestion, largely caused by illegal file sharing, has been addressed by proposing that the ISPs be denied the ability to manage that very congestion. The market appears to be addressing the problem now, but if regulation or legislation is deemed necessary, then I recommend that Congress consider the heart of the problem first, and that's illegal file sharing. Illegal file sharing is the problem, Mr. Chairman, and I encourage you and your colleagues to factor that issue into your further deliberations. Thank you very much for this opportunity to express my views.
Thanks so much. Carolyn Fredrickson, Esquire, American Civil Liberties Union, been before the committee numerous times, has been General Counsel and Chief Operating Officer for NARAL, the Pro-Choice America, has been a Deputy Chief of Staff to Senator Maria Cantwell, a Deputy Chief to former Senate Minority Leader Tom Daschle, a lawyer from Columbia University, and before that, Yale. We're happy to have you. We've got your statement, and now we'll hear from you.
Thank you very much, Chairman Conyers, Ranking Member Shabbat, members of the task force. It's a pleasure to be here to talk to you about net neutrality and free speech on the internet. The Supreme Court's ruling in Brand X and FCC inaction in addressing increasing censorship by broadband internet service providers, or ISPs, are key factors in today's threat to online free speech. This hearing marks an important step toward ensuring that the marketplace of ideas for the 21st century, the internet, remains the bastion of freedom that it has been since its creation. The internet's marketplace enhances speech through its decentralized, neutral, non-discriminatory pipe that carries data from origin to destination without interference. Neutrality promotes open discourse. Consumers, not gatekeepers, decide what sites to access among millions of choices. The internet structure facilitates free speech, innovation, and competition on a global scale, providing access to a mass audience at little or no cost. No one owns the internet. Instead, the internet belongs to everyone who uses it. The internet has become the leading 21st century marketplace of ideas because of neutrality rules promoting non-discriminatory speech, association, and content. The internet was born and flourished under well-established non-discrimination protections derived from Title II of the Communications Act of 1934, which grants the FCC the authority to regulate telephone companies as common carriers. As early as 1966, the FCC required that data transmissions going over the phone lines be provided on a non-discriminatory basis. The internet blossomed under that protection. Today, 3/4 of all adults in the United States, 147 million people use the internet, and 2/3 of American adults do so daily. Neutrality rules have made this dynamic growth possible. ISPs ignore this history by wrongly suggesting that non-discrimination would regulate the internet. The opposite is true. Non-discrimination ensures that lawful activity on the internet remains free from regulation by both the government and network providers. An ISP's First Amendment rights are not violated by neutrality rules that would bar an ISP from censoring its customers. Aside from the internet content that they create, edit, and maintain, which would not be restricted under neutrality principles, ISPs are not speakers. They are merely providing the wires through which each of their paying customers accesses the internet in much the same manner as telephone companies do for our phone lines. That is why the FCC was allowed to regulate ISPs as common carriers until 2005, when the Supreme Court ruled in Brand X that they instead may be regulated as information services. But ISPs exist to provide customer access to the internet and the expressive and associational activities found there free of censorship, akin to the role of telephone companies in providing communication services. We would not tolerate a telephone company restricting our calls to certain numbers based on the content of the call, and we should not tolerate that type of censorship from ISPs. A vibrant marketplace of ideas on the internet cannot function with corporate censors any more than it can with government censors. Without neutrality rules, ISPs are engaging in more and more online censorship. And Ms. Combs has already done a very fine job of outlining the variety of censorship activities that have happened just in the last year or two, so I won't restate those. But the ISPs have established through their very own actions that internet censorship is a growing reality and not the speculative hypothetical they claim it to be. Restoration of meaningful neutrality rules would simply return us to where we were before the Brand X decision in 2005 by prohibiting ISPs from picking and choosing which users can access what lawful content through the gateways they provide. Congress must pass legislation that enforces the 4 freedoms established by the FCC in its 2005 policy statement, including access to lawful internet content and running applications and services of one's choice, with penalties for violations of those freedoms. Otherwise, the internet will be transformed from the shining oasis of speech to a desert of discrimination that serves to promote only the ISP's commercial products, and so much would be lost from that change. Thank you very much for your attention.
Thank you for being on time. Wish you always are. I'm pleased now to turn to Professor Christopher Yu, University of Pennsylvania, who teaches telecommunications and intellectual property law, directs the university Center for Technology, and prior to his appointment, taught at Vanderbilt University Law School. He's published prolifically and has a new book coming out this year entitled Networks in Telecommunications, Economics and Law. He clerked with Supreme Court Justice Anthony Kennedy and is a Harvard graduate from law school, and I'm pleased to welcome him now at this time.
Thank you, Mr. Chairman, members of the committee and the task force. I'm grateful for the opportunity to be here today. The internet is perhaps the first major technological development of the 21st century. A network that began as a platform for email and web browsing now supports a dazzling array of new services. Perhaps the most important of these new services for policymakers is the emergence of internet video technologies such as YouTube and Views. These new applications are placing increasingly intense and varied demands on the network and have made network planning considerably more uncertain. For the past 5 years, internet traffic has grown at a rapid but steady rate of roughly 50 to 60% each year. Some experts estimate that internet video will cause that growth rate to double to 90% to 100% each year, as occurred during the first 6 years of the internet and is reportedly currently occurring in Japan. If these estimates are correct, network providers must increase their capital investments by over $100 billion, or else the internet will slow to a crawl by 2010. The key reason that the internet is the problems posed by the internet is that it is subject to congestion. In other words, the speed you receive depends not only on how many network resources you are using, but also how many other people are on the system at the same time. Internet technologies vary widely in their susceptibility to congestion. For example, cable-based technologies are more vulnerable to congestion at the neighborhood level than are telephone-based technologies. Cable modem service will degrade if as few as 15 of the 300 users in the same neighborhood are running BitTorrent. Wireless broadband technologies are even more vulnerable to congestion. In some respects, internet congestion arises in much the same way as congestion arises on our nation's road system. Like on the internet, the speeds that you can attain on the roads depend not only on your decisions, but also on how many other drivers choose to hit the road at the same time. In addition, like the internet, congestion on the road system varies from location to location. Therefore, any solution must be tailored to increases in volume that vary in time and space. There are typically two solutions to congestion. One solution is to build more lanes to make sure there's always enough capacity to prevent delays when traffic peaks. The problem is that building excess capacity is expensive. Maintaining extra resources that are only used a few minutes out of every day is typically a bad deal for consumers. The increase in capital costs threatens to slow the build-out of broadband services for all Americans. And the additional cost will raise the number of subscribers that a broadband network will need to break even, which means that the burden would fall especially hard on rural Americans. In addition, no matter how hard they try, planners' predictions of how much and where to add additional capacity will occasionally be wrong. Adding more lanes takes time, so when planners make mistakes, adding capacity is not always available as an option. Even more importantly, adding lanes often simply stimulates developments at the ends of the roads until the new lanes become congested as well. Thus, there is a real danger that demand will expand to fill all available capacity, no matter how many lanes are added. The alternative approach to adding capacity is engaging in some type of network management by limiting access to the interstates during rush hour, reserving lanes for high-occupancy vehicles and buses, and giving ambulances and other high-value traffic priority over other traffic. Each of these approaches involves a degree of non-neutrality, and yet each is regarded as uncontroversial. I do not mean to push the analogy between the road system and the internet too far. There are some critical differences between them. For example, internet traffic is extremely bursty in that long periods of inactivity are punctuated with extremely brief but intense periods of heavy bandwidth usage. This makes network management considerably more complex and calls for different tools. Perhaps the most important difference between the road system and the internet is the presence of bandwidth hogs. In the road system, each driver causes roughly the same amount of congestion. On the internet, the situation is quite different. Network providers estimate that as few as 5% of end users represent between 50 and 80% of the network's total usage. And many applications are designed to increase their usage as long as capacity is available. The question in such a world is not whether congestion will occur. The question is whether the cost of that congestion will be borne by all users or only by those responsible for causing it in the first place. Good economics and simple fairness favor placing the lion's share of those costs on those responsible for creating them. Any other system would in effect require low bandwidth users to cross-subsidize the network usage of a handful of bandwidth hogs. It is for this reason that every panelist that testified at the FCC's February 26th hearing on network management agreed that some degree of network management is inevitable. The problem is that the reasonableness of any particular approach to network management varies from technology to technology, and within any particular technology varies across time and from location to location. The problem is complicated still further by the fact that technology underlying the internet is undergoing constant and rapid change. At the same time, the current debate has failed to take into account the proper analog to the internet is not the one-to-one communications that characterize the telephone system, but rather the one-to-many communications that characterizes the internet. The flood of internet content, in short, internet users face an avalanche of content every day and depend on search engines, bloggers, and other intermediaries to help sift through it. Consumers also depend on them to protect them against undesirable content such as spam, viruses, and pornography. The question is thus not whether there will be an intermediary. The question is who will serve as that intermediary. And in fact, there are a great deal of problems, as the Christian Coalition's position in this, for the FCC makes clear. We do depend on network operators to screen us against pornography, ringtones with racial slurs and profanity, and other forms, and we must be careful that in asking companies to serve as intermediaries, that we do not stop their ability to do that. The precise details of which agency, whether agencies or courts should enforce, are less important than the substance of the law. I would urge this committee not to rule out any particular solution off the table. Leaving network providers free to experiment with new solutions is the best way to ensure that consumers enjoy the full range of the internet's tremendous potential in the future. Thank you.
Thanks so much. Professor Susan Crawford, Yale Law School, also has taught at Cardozo School of Law in New York, Georgetown University Law Center, Michigan University, a policy fellow at Center for Democracy and Technology, and sits on the board at the Internet Corporation for Assigned Names and Numbers. We welcome you to the committee.
Thank you so much, Chairman Conyers, Ranking Member Shabbat, and members of the committee. It's an honor for me to be here today and talk to you. I want to leave you with just 3 key points. First is that the stakes are extraordinarily high for this discussion because the internet is becoming the general purpose communications network on which all Americans rely for both business and personal reasons. And second, that there are clearly insufficient protections in place for both speech and innovation online. As the chairman pointed out, we have an unregulated duopoly in place providing Americans with internet access at the moment, and they have enormous market power and every incentive to discriminate against speech and new products and new services that they believe are undermining their business plans. Third, congressional action is needed to ensure in advance that we have an open, neutral internet to which all of us can have non-discriminatory access. Just a few words about the context here. We make a deal over and over again with the providers of general purpose communications networks. Here's the deal. In exchange for limiting your liability for the content of the communications that pass over your network, we make them provide non-discriminatory assistance to all customers who are willing to pay. We've done this for the telegraph. We've done this for the telephone. This is not a new obligation. It has allowed us to put our general communication systems in the hands of private, for-profit companies without worrying about discrimination and censorship. We're at a constitutive moment in communications history, a real turning point. This is like the moment of the arrival of the telegraph and the telephone. Now it's the internet. The internet is the first global, electronic, general-purpose communications network. It's triggering economic growth and new ways of making a living all around the world. The internet is not the same thing as Comcast cables or Verizon's wires or even a wireless connection. These companies are merely providing one set of connections that allow users and businesses to connect to the dynamic interaction that the Internet protocol facilitates. The stakes for this conversation could not be higher. The difference between a phone, a cable system, and television, they're all dissolving. The Internet is taking over the functions of all of these communications networks we used to use. Each of the vertically integrated network access providers in this country sees this change as a threat. Telcos want to offer their own premium television services, music services, and premium web content. Cablecos want to offer more channels of cable content. Cable companies limit their Internet access services to a very small amount of bandwidth. In fact, the real bandwidth hog here is Comcast in many ways, because that's only, Internet access is a tiny portion of their overall bandwidth. The rest is devoted to cable content. The open Internet could become the greatest competitor these companies have ever seen. Again, it's not one competitor, but a general purpose vehicle for thousands of entrepreneurs across the country offering innovative new products. Each of these dominant network access providers, as you've heard from Professor Yu's testimony, wants to act as an editor or a gatekeeper of Internet access for their own commercial purposes. They want to call these edited services Internet access, but it's not really that. It's much more like more cable content. These guys don't want to be gravel pits. They don't want to provide commodity transport. We have a choice right now. Should we have a general purpose network available for all Americans to use in a non-discriminatory fashion, like a road from a rural center to a big city? Or should we have a series of special purpose networks that are much more like rides in Disneyland, carefully managed, the whole consumer experience one that's tailored to the competitive needs of the network access provider? The stakes are very high. This is about the future of communications itself. Second, there are clearly insufficient protections for speech online. As the chairman clearly outlined, we do not have a functioning competitive market for Internet access in this country. Instead, we have regional duopolies offering either DSL service or cable modem service to 96% of the country. A third of Americans have at most one choice of high-speed Internet access provider. This lack of competition provides the opportunity for discrimination with respect to Internet access services, and that discrimination in turn serves the goal of these large carriers. It's so easy to come up for explanations for discrimination after the fact. Arbitrariness by itself is enormously threatening to speech and innovation and has the potential for suppressing particular points of view, as the Christian Coalition points out. So congressional action is needed. That's my final point. All of these Internet access related questions are being dealt with under the FCC's assertion of ancillary jurisdiction. There is simply no express congressional mandate for how to deal with Internet access. We should not allow a key source of America's economic growth to be subject to such ad hoc authority. Congressional oversight, particularly from this committee, is needed. Thank you very much.
Crawford would say to you. Thank you. Professor, you're in a tough place here because you're between two female lawyers. And I wonder, Steve Chabot and I are wondering what would happen if we left you, to your own devices and see what would happen. Now, over here, we've got two songwriters, and is this new school versus old school on this situation?
No, it's not, sir.
Oh, it isn't.
He's the future of Music Coalition. I guess that makes me the past of Music Coalition.
And then Attorney Fredrickson and Ms. Combs have rarely agreed on anything, and they come together in harmony this afternoon. Isn't that amazing? So your chairman wonders, what would you say, Mr. Kulash, to Mr. Carnes, and what would our two lawyers say to Professor Yu?
I'll take the Kulash question. There's no reason that the law shouldn't apply on the internet. What we're looking for is a vibrant, realistic digital marketplace for music, and I think that can only happen if we let the innovators come up with the system instead of deciding right now that one of the two companies existing can make that system happen.
Mm-hmm.
To which I would reply, when you say net neutrality, the internet is not neutral now. It's set up for the benefit of the 5% of bandwidth hogs that are using 70% of the bandwidth, 90% of which is illegal content. And in terms of freedom of speech, I would like to remind you that this it's all copyrighted material that's being stolen. And the Supreme Court has said that copyright is the engine of free expression.
Well, you know, this committee has just put out a pro-IP bill with all kinds of additional protections.
And we appreciate that, but they also removed the civil enforcement from the bill by the FBI, which is in the Senate version, but it's not in the House version, which is really critical for us.
Are you a lawyer as well?
You know,
just
I'm
inquiring.
not. I actually
didn't
have
notice.
CDs for sale. I wanted to say that.
Now, Professor, do you have any last comments before we leave you to the people on your immediate right and left?
Thank you for allowing me that, Chairman.
Well, it's like making your last statement before you're executed.
I guess if I would make one point at this point, is that I do believe the competitive market can work here in ways that are unappreciated. The Chairman, you mentioned that there's a duopoly. There's actually tremendous from a much more competitive environment. From having 0 subscribers in 2004, wireless broadband by the end of 2006 signed up 21 million subscribers. And by the end of 2007, they estimate it has doubled again to 45 million subscribers. What we find from the record in the FCC proceedings is things like network management, which we regard as non-neutrality, are critical for wireless subscribers to survive, to introduce the very competition that the Antitrust Task Force recognizes as essential for a long-term solution. And in fact, one of the points made by a very small rural wireless carrier named Lariat, run by a gentleman by the name Brett Glass, says that he's got such limited bandwidth and his cost margins are so tight that the only way he can survive is by cutting down on a handful of BitTorrent users on the moments that the volume peaks. And the reality for him is that if we do not allow him to manage the network in that way, the kind of competition which we are saying is the goal will not occur.
Mm-hmm. Well, what do you say, ladies?
Well, I think from our perspective, the essential factor here is free speech and the ability to communicate. And whether or not the ISPs need to engage in some kind of network management, I think is a question for technologists more than it is for those of us on this panel, except to the extent that it's non-discriminatory is the major focus, I think, of this, that should be of this committee and of legislation, to ensure that whatever network management, as Professor Crawford has noted, not be taken and used as an after-the-fact justification for discrimination. So that's why I think it's critical that the committee consider legislation that would have set up neutral rules from the beginning to ensure that no discrimination takes place and network management not be covered to eliminate certain types of content.
And just to follow up on Ms. Fredrickson's remarks, we did this successfully in the 60s. We kept the phone companies out of the business of data processing. They were quarantined out of that business, and that was a very successful way of not having to get engineers into writing legislation, but just keeping an old industry from controlling a new one. And that's the risk we're facing here. Now, a lot of this is talking about money. I understand that for about $1 per subscriber per month, a cable system could run a neutral network. It saves them, I understand, Comcast, something like 10 cents per subscriber per month to do the kind of traffic shaping they're doing. This is not about that. This is about, from their perspective, the risk of a precedent that they be treated like a general communications carrier when it comes to internet access. They should upgrade their networks.
Mm-hmm. Ms. Combs, are all the ladies on this panel in agreement this afternoon?
Yes, we are.
I thought so. Well, on that note, we'll take a brief recess for a vote, and we'll be right back and recognize Steve Shabbat.
Say, we've actually worked with
Yeah, we didn't do it by
number
gender.
of
That
other
was not the
issues.
idea.
Yeah, we did. So perhaps not.